How is child support calculated in Florida? I'm Adam B. Cordover, a collaborative divorce attorney here in Tampa Bay. Child support in Florida is based on a set of guidelines created by the law. In simple terms, it's a formula designed to make sure your children's basic financial needs are met after a separation. At a high level, the calculation looks at three main things: your income and your spouse's income, the number of overnights each parent has with the children, and how certain expenses are handled. Let's break that down a little further. First, income. The law looks at all sources of income, not just your paychecks. If you own a business, for example, your income includes the extent to which the business is covering personal expenses that you would otherwise pay for. If your spouse is receiving investment assets in the divorce, we may also consider whether those assets could generate income for your spouse. And if alimony is involved, that amount is usually deducted from the payor's income and added to the recipient's income before child support is calculated. Next, overnights. The more time each parent spends with the children, the more that can affect support amount. Keep in mind that by default, Florida says that children would spend 50% of the time with each parent, though the parents can agree on a different time-sharing schedule. Then there are specific expenses. The guidelines can factor in things like health insurance premiums for the children, non-covered medical expenses, and certain daycare costs. Child support is meant to cover your children's basic needs, like their share of housing, food, and everyday living expenses. But above and beyond child support, there are expenses that are usually handled separately, like extracurricular activities and additional medical, dental, vision, or psychological expenses. If the parents have similar incomes, then these expenses may be split 50-50. If there's a big difference between each parent's income, then usually there is a proportional split. So if a parent has 70% of the family income, that parent will oftentimes end up 70% of these certain expenses. One important thing to understand is that child support is considered the right of the child. That means you and your spouse generally cannot waive it altogether. That said, families do have flexibility in how support is structured if they do so by agreement. For example, instead of one parent simply paying the other, you might agree to directly cover certain expenses or contribute to a college fund. One other thing to note is that without an agreement, a court typically cannot require parents to pay for college, but if you choose to plan for it together in an agreement, that agreement will become enforceable. In a traditional court case, a judge applies the formula and makes decisions if you can't agree. That process can feel rigid, public, and sometimes disconnected from your family's day-to-day reality. In a collaborative divorce, you and your co-parent work together with your attorneys and often a neutral financial professional to make sure both spouses understand each other's income and the guideline amount. Then you can explore options that make sense for your family. That allows you to create a plan that is private, informed, practical, and child-focused. In my work with families across Florida, I often see that when parents understand how the numbers work, it becomes much easier to shift from conflict to problem solving. And the good news is that you don't have to figure this out on your own. You don't have to do it in a public courtroom during an adversarial proceeding. In fact, we invite you to schedule a virtual planning meeting by calling us at 813-443-0615 or visiting us on our website at familydiplomacy.com. We work with clients in every county in Florida, and we also have offices available by appointment in Tampa, St. Petersburg, and Sarasota. When discretion matters, count on us.